This courtroom is not playtime. This is Judge Raquel West's court, and today you're about to see how fast a guilty plea can turn into years behind bars. What happens when someone leaves the scene of a deadly crash, and how probation can vanish in seconds when you don't follow the rules. Watch Shayna King admit to a felony burglary. Then stay with us as another defendant faces 15 years after a fatal accident. Plus, a tense moment where immigration status becomes part of the sentencing. We're also going to see a live fight over trial prep, a competency ruling, and one of the harshest sentences you can get in Texas, aggravated sexual assault of a child. Pay attention to how the judge explains rights, appeals, and firearm bans, because every word here changes somebody's life.
You have to push the button.
I tried both buttons.
So it should be second.
It's a second.
It's a
Okay,
second.
I got it.
Yes.
All right,
Sorry
ma'am,
about
are you, that's okay. Are you Shanna King?
Yes, ma'am.
And Mr. Wilkerson, will your client waive the formal reading of the indictment?
Yeah, sure.
Ms. King, in cause number 250295, you're charged with the second-degree felony offense of burglary of a habitation, and that's from December 13th of 2024. And how do you plead to that charge?
Guilty, ma'am.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Wilkerson?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. King is not competent?
No, Your Honor.
What you just watched is a textbook felony plea and sentencing start to finish. In under 3 minutes, Ms. King is charged with burglary of a habitation. That's entering someone's living space without permission and with intent to commit a crime. In Texas, that's a second-degree felony, which typically carries 2 to 20 years. She pled guilty voluntarily. The judge confirmed she understood the deal, and then immediately sentenced her to 6 years in the Texas Department of Corrections. Notice 2 key warnings. First, no right to appeal because this was a plea agreement, meaning she's basically locked in. Second, she's now legally banned from owning or even possessing a firearm or ammunition. The judge is making sure she can't say later, "I didn't know." Question for you. If you were the victim of this burglary, does 6 years sound fair or light?
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. Sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Wilkerson.
We're now moving into a case that's emotionally and legally heavier. Accident involving death. This charge comes from a deadly incident where the defendant, Johnny Jacob Rayoni, hit a pedestrian and then did not stop. In Texas, failing to stop and render aid when someone is seriously hurt or killed is itself a felony. The defense is about to argue for less than the 15-year cap, and you'll hear something important: immigration status. His attorney points out that even if the judge wanted to consider probation, there's an immigration hold, meaning federal custody would step in and he wouldn't actually walk free. That's huge, because it affects what's realistically possible at sentencing. So ask yourself as you listen, is this a panicked mistake? Or is this a pattern of choices after the crash?
All right, good luck to you, ma'am. You can go back with the bailiff.
Do I take this with you? Okay, thank you.
Good morning. Are you Johnny Jacobo Ramon?
Yes.
And Mr. Ramon, you were previously in court and entered a plea of guilty to the second-degree felony offense of accident involving death. And that was a plea agreement of a cap of 15 years in prison. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
Defense has. Yes, Judge.
Are there any additions or corrections?
No, Your Honor. Not from the state.
Mr. Burbank, you may proceed.
Your Honor, this is a tragic accident. If you read the factual basis, which I know you did, the person was walking across the street at nighttime, and cars swerved, and my client actually hit him. As reflected by the charge, he failed to stop. He panicked, as in reference to his version, that is on page 1, and then was stopped up in Lumberton. He's been employed. He has family up in Woodville. He's been employed. He's got one problem. He is not a U.S. citizen. I would be arguing for probation in this case, but it is my understanding that there is a hold on him by immigration, and that he probably will not, if he got probation, he wouldn't be released. He has 2 prior DWIs from Tyler County that were taken care of at the same time. What you received, basically time served, 90 days jail. The intoxication charge that I believe is from Hardin County was when he was arrested, and that's been dismissed or rejected by the, and probably because we're down here, they probably did it. Your Honor, I asked for there's a death involved, and I would love to have the minimum in reference to penitentiary time, but I'm asking for mid. I think that 15 is probably too harsh, and that's my opinion, especially in light of the facts and circumstances of this, in which the person was walking across the street at the time and being blocked by other vehicles, and other vehicles had to get out of the way. But he was definitely wrong in not stopping, and he was intoxicated. I would ask for anything less than the 15 because I know where he's going to go.
You just heard the defendant say, "I didn't know I hit someone," and offer an apology. That matters emotionally. Judges do listen to remorse. But watch what happens next. The state is going to argue that he absolutely did know. They're going to point to his phone calls the next day and say he lied to police, claiming he hit a deer. They'll also highlight intoxication and behavior in custody to paint a full picture of judgment and character. Here's the clash. Defense says panic and fear. Prosecution says evasion and dishonesty. Which one do you believe here? Honest mistake in the dark, or hit-and-run cover-up?
And that's a sad thing, but he's not here legally. And I don't know if he would like to address the court.
Sí,
Yes, sí.
Go ahead.
quiero decir que lo siento, que si lo hubiese visto, yo me hubiese detenido antes para poder auxiliarlo, pero pues
Hold on.
Judge, I'm so sorry. Had I seen him, I would have stopped and helped and rendered aid.
pero pues había un carro con
Hold on.
atravesó.
Hold on. So are you telling me that you didn't know you hit someone?
¿Me está diciendo que usted no sabe que le pegó a alguien?
No, sí.
I did know.
Okay.
Pero pues había un carro enfrente y yo no lo pude ver
There was
antes.
a vehicle in front and I wasn't able to see him on time.
Okay.
pero pues quiero decir que lo siento.
I wanna say that I'm sorry,
Si pudiera volver el tiempo lo haría, pero
but if I
sé
could
que
go back in time, I would go back and
soy
help,
el culpable.
and I know I'm guilty.
Okay, thank you.
I just have one question up here. What were you doing for work?
¿Qué estaba haciendo de trabajo?
Estaba en el roofing
I was a roofer.
And how long have you been, in the country?
¿Cuánto tiempo has estado aquí en los Estados Unidos?
14, 15 años.
14, 15 years.
And have you always had a job?
¿Siempre han tenido un empleo?
Sí,
Yes.
And you do have a family?
¿Y si tienen una familia?
sí.
Yes.
Thank you. Mr. Smith?
Judge, we would argue for the max sentence in this case under the plea agreement based on the fact that when he struck him, he knew that he struck him. That was evidenced by the phone calls. The next day, he knew he hit a person. When he was stopped in Koontz, which is a long way from the accident scene, he told the police when they noticed the damage on his vehicle that he had struck a deer. They, either through dealing with him before or suspecting that he was lying and knew he was intoxicated, went all the way back to the county line looking for a deer that had just been struck. And only because they were diligent in doing so did we even know that he had committed this particular crime. He knew he committed the crime. He lied about it. He has an issue with alcohol. He's here in the country illegally. I would direct your attention to the jail report in this case and how he's acting, showing disrespect for staff as well as masturbating in open bunk. We ask for a 15-year sentence in this case.
Mr. Jacobo Ramon, obviously the facts of the case are terrible. The fact that you didn't stop. The fact that you were intoxicated. And in addition, and I'm not even sure that when you were in our jail for some amount of time, there was a requirement that I release you because of the amount of time that had gone from the time of the offense while you were sitting in custody. I did that, and then you didn't show up.
Right here is where you feel the judge's weight. She's about to hand down a 15-year sentence, and listen closely to her reasoning. It's not just about the death, it's about failing to stop. Being intoxicated, and then not showing up to court after she once released him because of a legal timing requirement. Judges keep receipts. When she says, "You are here illegally and have now killed someone," that's not just commentary. She's building a record, danger to the public, lack of compliance, and risk of flight. From her seat, this isn't just tragedy, it's public safety. Do you think 15 years is justice here, or is it too harsh?
You are here illegally and have now killed someone. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. And at this time, find you guilty of accident involving death. Sentence you to 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. It is in Spanish. I advise you to read that. If you are ever back in Texas legally, you will not be able to possess a firearm or ammunition. That could lead to more charges against you. All right, Thank you. You can go back with the bailiff. Thank you, Mr. Burbank. Thank you, Ms. Burge.
Yes, ma'am.
Thank you.
Good morning, sir. You're Corey Flemings?
Yes, ma'am.
And Mr. Flemings has two cases, cause number 24-2144 and 24-2145, set for trial to begin with jury selection on Monday, the 23rd. And what is the announcement?
We'll be ready, Your Honor.
All right.
State's ready, as far as I'm aware, from Mr. Coleman, Judge, I would ask that Mr. LeBlanc make a request for the media if he has not done so already, since we have a bit of time in between.
Okay. Have you asked for and received the media?
I believe this is the one, yes, I've asked for it, but I haven't received it. I think I have I'll have to check if I have it in my office, but
It's
at any rate.
okay.
Be ready.
Well, but if your client hasn't seen the videos or any type of media with you, then how do you know for certain that this is what is the appropriate end game? Because he hasn't seen, I would assume in an assault on a peace officer, there's body cam footage that might affect what agreement there is. Do you know if that is, can that get ready today?
Yes, Judge, it doesn't look like it was marked as requested and received, but I can follow up on it.
I want that done today.
Yes, sir.
I want you out to see Mr. Flemings by tomorrow
Yes, sir.
to review that with him. And I want to know by tomorrow at noon that it has been done and that in fact this is what Mr. Flemings wants to do, is go to trial after seeing that. All right? I want to hear from you at noon tomorrow. Okay. You can go back with the bailiff.
If you're enjoying this inside look at real court cases, make sure to hit that subscribe button and turn on notifications. We bring you real courtroom drama, shocking verdicts, and all the twists you won't see anywhere else.
Good morning. Are you Christopher Falk? Yes, ma'am. And this is cause number 24-1891. Mr. Falk is charged with assault on a public servant. There was a request to have Mr. Falk examined for competency to stand trial. Dr. Grapon did that evaluation. I've received that report dated May 30th of 2025. It has the finding that Mr. Falk is currently competent to stand trial. Is there any other evidence with regard to competency?
Nothing. No, Your Honor.
All right, then based on that, I am going to find at this time Mr. Falk competent to stand trial. And do you need some time for an announcement, or are y'all ready to make an announcement today?
A little more time, Judge. I have talked to him a little bit since we've gotten the report back, but I think we need to talk to State a little more and see if we can get it worked out.
All right, I'll reset that one more time, and then we'll see if we can get an announcement at the next court date. Is that your computer? That's okay.
Do I need to get the bailiff?
All right, we'll reset it. We'll get an announcement at the next court date. You can go back with the bailiff. And then you've got David Tillman to for that to be done. I'm thinking about something else. All right, sir, are you David Tillman?
Yes, ma'am.
And, all right, so it looks like there is we've got cause number 22-40540 and 24-0536. And will your client waive the formal reading of the motion and the indictment?
Yes, ma'am.
Just a second to get there. Okay, Mr. Tillman, in cause number 24-0536, you are we going on count one only?
Yes, sir. Yes, sir.
God bless you. The state has elected to proceed on count one only. It alleges you committed the first-degree felony offense of aggravated sexual assault of a child from August 15th of 20.
This part looks quieter, but it's actually huge. We're now with Corey Flemings, who has 2 pending cases headed for trial. The judge is not playing around about evidence. She basically says, has your client actually seen the video evidence, including possible body cam footage from an alleged assault on a peace officer? Why does that matter? Because a defendant cannot make an informed decision about a plea, or whether to risk trial, without seeing exactly what the jury will see. If the body cam shows excessive force, that helps the defense. If it shows him attacking an officer, that helps the state. Notice how the judge orders the state to get that footage to the defense today, and wants confirmation by tomorrow at noon. That's accountability in real time. Question for you. Should every judge be this aggressive about making sure defendants see the evidence before trial?
Of 2022, and how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yeah, yes.
And are you pleading guilty because you actually did what they charged you with?
Yeah.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
And do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
Also in this case, do you understand that you will be required to register as a sex offender? It looks like you've signed that paperwork, and have you gone over that with Mr. Lewis as well?
Yes.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Tillman is not competent?
No, Judge.
All right, Mr. Tillman, in cause number 240536, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated sexual assault of a child. Sentence you in accordance with your agreement to a term of 20 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Okay, and then,
And it's a little confusing, Your Honor. The motion does not contain that the offense he just pled guilty to, because the dates, the new offense predates him
Gotcha.
being put on probation, so it's
Okay.
not part of the revocation.
gotcha, thank you. All right, and then in cause number 2240540, I have a motion to revoke your community supervision. Shows that you were placed on probation May 1st of 2023 for the offense of unlawful possession of a firearm by a felon, and that was a 10-year term in prison that was probated for 6 years. Is that correct?
Yes, ma'am, that's true.
And it alleges that you violated your probation. Count 1 alleges that you failed to provide verification of performing the community service hours as required. And is that true or not true?
That's true.
Count 2 alleges that you failed to provide verification of entering and successfully completing the MRT, the Moral Recognition Therapy Program. Is that true or not true?
That's true.
And then count 3 alleges that you are behind in your court-assessed fees. And is that true or not true?
That's true.
Did you enter your pleas of true to each of those counts freely and voluntarily?
Yes, ma'am.
And did you plead true because those counts are actually true?
Yeah, true.
I also have some documents here on the computer in that case that have your signature on them that the state's marked as exhibit number 1. Did you also go over these with Mr. Lewis?
Yes, ma'am.
And do you fully understand them as well?
Yes.
And do you understand, again, if I follow the agreement in this case, you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. All right, Mr. Tillman, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. find those counts true, find sufficient evidence to revoke your probation, and at this time revoke your probation, sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These two cases will run concurrently, which means together at the same time. I'm handing you now, in each of your cases, the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. We already went over that when I put you on that probation. I just want to make sure you understand, based on the judgments in both of these cases, you are ineligible under Texas law to possess a firearm or ammunition. If you have any questions about that, make sure you read that document and talk to Mr. Lewis.
Yes, ma'am.
All right, good luck to you, sir. You can go back with the bailiff.
I have one question.
Yes, sir.
Does the time I get credit also include the time I was in Oklahoma?
So the time that you will get credit on is any time that you were either in our custody or that we had a hold on you. So if we had a hold on you from Jefferson County and you were in some other place being held, then yes, you would get that. If we did not have a hold on you, then you would not.
Right.
Okay? Yes, sir.
Now we're closing with maybe the most severe outcome of the day. David Tillman pleads guilty to first-degree aggravated sexual assault of a child that is one of the highest-level felonies in Texas. The judge confirms he understands the plea, understands that he'll have to register as a sex offender, and understands he's giving up his right to appeal. She then sentences him to 20 years. That alone is huge, but it's not over. Tillman was already on probation in a separate case for unlawful possession of a firearm by a felon. The state files a motion to revoke that probation, and the judge goes count by count. Missed community service, didn't complete required programs like MRT, that's moral recognition therapy, which is meant to change criminal thinking, and he's behind on court fees. Tillman admits those are true. Result, probation revoked, and he gets 10 years in prison on that case, to run concurrently with the 20-year sentence. The judge also goes on record again about firearm bans, making sure there's zero confusion later if he's ever released. This entire docket shows how fast things move once you're in front of a Texas felony court. Guilty pleas lock in waivers of appeal. Immigration status can shape sentencing. Mental competency can decide whether a trial even happens. And probation is not a shield if you stop doing the work the court ordered. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Who do you think got the harshest but most justified sentence today? King Raoni or Tillman? Your take might show up in the next video.